recognition of nations, individuals, and land. And the basics of this are really just to understand identity and who gets to determine identity, how basically the federal government kind of defers to tribes for identity things. It's not a really significant chapter. The case about the United States versus Cruz is kind of interesting. I'll try to just give you the skinny on that one quick. Then we got a definition of Indian country, which is kind of late and kind of unusual. And then the vague terminology regarding the dependent Indian community. So anyway, nations. What is a nation? Let's see here. Go back and forth like that. Okay. The one point that your author wants to make in this chapter is just to remember that tribal nations, I was writing about this today, believe it or not, in a course, what we call them, the general education justification thing. And for this class is considered a diversity course, a D course. And the university has general education designation standards. And for the diversity courses, they they try to phrase this real carefully, of course, but they want courses that are focused on underrepresented groups. And generally that underrepresented group shorthand implies, groups determined or groups that are defined by race, ethnicity, gender, age, ability or disability, sexual orientation. I said gender, but there's also a gender identity. So, and the list goes on and on. The interesting thing about, I think, this course is that all of those groups, of course, are defined in their own way. Some, maybe more obvious than others, but generally those groups are defined at least partially by the members within the group, and not necessarily by the United States government. So that's one way that Indian nations and members of federally recognized Indian tribes, and also non-federally recognized Indian tribes and state recognized Indian tribes, are different from all other underrepresented groups, whether they be racial, ethnic, what have you. And so, none of those groups are partitioned off in the United States Constitution the way that Native American tribes are. So just a point here that members of sovereign tribal nations, and I'll try to use that term, sovereign tribal nations are distinct from all other underrepresented groups in the United States. I guess I answered the question. Sorry about that. Is this true? So yeah, did I miss something? How else are they different than all other groups? Their definition is, I'm not sure if you recall reading this, but their definition is one that is political rather than based in a right that's protected by the Constitution. So they are defined by Congress. Okay, so hey, Steve's here. Great, we got 3 online today. Cool. So anyway, that's just one part of that first area I want to cover. And now I mentioned state recognized tribes and unrecognized tribes, and you are all familiar with federally recognized tribes. being federally recognized is very, very important for a sovereign Indian, sovereign tribal nation, right? What does federal recognition bring? Well, okay, we'll see. We'll see about that when we get to land today. In fact, um, but federal recognition is really required for an Indian tribe to enjoy any of the benefits um, of sovereignty and within the United States federal system. So, um, the recognition of a tribe by the United States federal government um, allows such a such a tribal or nation to to be covered by all of the federal statutes, um, and probably not a treaty if they're just recently getting recognized, but all of the federal statutes and the United States federal court rulings that are pertinent or relevant to tribal nations. Right? If you're a member of an American Indian society or culture or group that doesn't hold federal recognition, then there is no recognition. You don't, there could be the existence of a community, but that group will not enjoy the same privileges as those which are federally recognized. Now, there are also state recognized tribes, particularly in the former 13 colonies, the areas where states, or at least the colonies, had made treaties with Indian tribes. There are still a lot of tribes that are seeking federal recognition in those states, relatively small groups of people. But what? Okay, I'll just kind of deviate here with a question. Your textbook explains that those, or your author explains that those state recognized tribes are not recognized by the federal government. Okay, they are recognized by their own state government. So, what would it be possible for those state recognized tribes to have Indian reservations? Anybody want to guess? Well, yes. The answer is, in fact, there are reservations that are state reservations, Indian reservations um, that are created by the states, and they are typically areas where these state recognized tribes exist. No, not federal recognition necessarily. And so there are reservations that are referred to as sort of state reservations, not not federal trust lands. There are also well, okay. Ask you a question. What do you suppose? What do you suppose states in general? How would they? Um, how would they cooperate, or would they not cooperate with Indian tribes seeking recognition within their boundaries? Say an Indian tribe or a group,
Not.
say a group of people couldn't get federal recognition, all right, but maybe they would seek state recognition. Well, it's
I
kind
think
of
they
go
I
ahead.
think they would. Just both of them could see the benefit of their compacts, etc., stuff like that.
Today, I think that's right. Um, if we the one issue though is most of the time states would want to cooperate with tribes, if there's some kind of return on that, you know that relationship, like in terms of gaming or something. However, there's a problem, and that is if a tribe wants to engage in gaming, then it typically would want to provide gaming in the way that the federally recognized tribes would, which would be subject to the Indian Gaming Regulatory Act. So to be subject to federal law, you have to be federally recognized. All right? But there might be other reasons, maybe in terms of um, state and tribal compacts, businesses that might benefit from having um, uh, a tribal organization operating. But anyway, most of those state recognized tribes and most unrecognized tribes are seeking federal recognition. So the question is, what is the rule? What allows a group to petition Congress, right, and seek federal recognition? Federal recognition. All right. So I guess I kind of went over that slide before I turned it. But what are the criteria for federal recognition? These are just kind of complicated. I mean, these are just kind of, I guess we'd say, administrative types of rules. But they have to, there has to be 4, I believe, of these things, or maybe they all have to be recognized. See, the criteria for acknowledgement as federal recognized Indian tribes are delineated in paragraphs A through G. So all of these have to be apparent. And which one of those? Okay, so an Indian entity identification. In other words, there has to be some tribe or band or clan or whatever, a town. Those are all possibilities. There has to be some sort of a social organization that can be identified, and usually with a name. So that's the first thing. It has to be, and it has to have been around. That term has to have been used since, and this is the magic date, 1900. Right? Why 1900? I'm not really sure, but it's kind of arbitrary. The second criterion is the existence of a community. Okay, so the group or the entity has to have been a community since 1900, all the way through to the present, more or less consistent in terms of existence. The third requirement is the presence of some sort of political organization, some sort of governing body. That could even be, it doesn't have to necessarily be a council, tribal council. It could be, maybe a board or just a group of elders. It's really not that stringent. There also has to be some sort of governing document, like a charter or a constitution, of course, or just some sort of paper trail that would show that this is an organization that's been around. And then, of course, there's dissent. The groups have to have some connection, some historical descent from an historical known group. And there are lots of those that are not federally recognized, surprisingly, maybe not surprisingly. There are lots and lots of groups that have a record of existence, because of traders or anthropologists have documented them, but they're not federally, they don't have federal recognition. In that case, they may be considered a dependent Indian community, right? Which is a vague term. Then there is the requirement to have unique membership, and I'm going to discuss that in the next slide. It's a little more complicated. And then also they cannot be, number 7, they cannot be a group who has been terminated or otherwise denied recognition in the past. So once you go up, and if you're denied recognition flat out for some reason, I don't think there's a rule that says you can't continue to try to do it. I think you can. But let's look at that number 6, the unique membership category. What is required here is that the group has to be, or the membership has to be composed mostly of persons who are not members of an existing federally recognized tribe. Well, that might seem to be obvious, right? However, it's frequently the case that newly recognized tribes are sort of silent parts of existing federally recognized tribes. A lot of tribes, as you know, were either voluntarily or involuntarily grouped together in the treaty era and in the removal era, so that and it's also the case that there were sort of smaller subgroups within larger tribes that removed. And a good example of that here, and we're in Tulsa, so the Creek Nation was actually a confederacy of many different groups, many different small tribal groups, and with individual languages or at least dialects of Muskogean. And those individual groups were generally treated as one group. The United States typically did that, and referred to them as the Creek Nation. But over time, some of those groups have begun to splinter away as their own entity, particularly after the 1980s, when the Indian Gaming Regulatory Act came about. So it maybe makes sense for some tribal groups to assert their own identities from out, to basically break away from the tribe, or they might have a designation within the tribe. But the Creek Nation is one of the most interesting tribes to me like this, because they not only have individual groups like the Yuchi, okay, but they also have tribal towns. And members of a tribal town can have an individual or have a recognized status. So they're a very complicated, geopolitically complicated tribe or nation. So another example of, can any of y'all think of another example of a sort of a group that has broken away from a larger federally recognized tribe? Well, okay, more of the, sorry about that, I don't see it now. More of the part of that, the group has to demonstrate some sort of existence of community and political authority, of their own, and any members who want to join that group have to self-identify. In other words, they can't decide, oh, well, I want to be a part of this group as well as this group. All right. So they have to break away. And of course, that creates some problems sometimes in tribal politics. So were there any examples that y'all could think of? The Cherokee Nation had a traditional group known as the Katuwas. And they broke away and formed their own, have their own federal recognition now in Tahlequah. And so they have a presence in the area within the Cherokee Nation. So that's but going on more to the federal recognition, basically most tribes want to get federal recognition because that means, well, it's pragmatic, for one. But who decides who is an Indian, who is a member of a federally recognized tribe? Today, most of the time, tribes have that privilege. The tribes themselves can create that designation. Some tribes are more conservative, perhaps, than others. For example, in some tribes, if the I guess I should mention blood quantum too. The term blood quantum is really associated with the allotment era, although it was maybe around before that. And in the allotment process, it was the case that, um, number one, there were certain, allotments went out typically to each citizen, but when it came to the Berkey Act and afterward, um, the removal of restrictions on allotments could be done earlier depending on the blood quantum of the allottee. Everybody get that? So if you were a full blood, so-called full blood allottee, then most of the time you really couldn't get, it was very difficult to have restrictions removed from your allotment. Okay. Um, and this is where the what do they call them? The guardianship people came in, and because those individuals could never really have their restrictions removed themselves, they would often allow a guardian to take over their financial affairs, and those guardians could do all kinds of things with that asset. So in the case of allotment, again, if you were like a quarter blood or less, then most of the time you could petition to have your restrictions removed pretty quickly. All right, so blood quantum became a big issue. Most blood quantum today is calculated based on the ancestry to a your own ancestry, um, uh, your relation, okay, your past ancestor, who was listed on one of the tribal rolls or several rolls. Okay, so tribal rolls were taken before removal in some cases. They're not real common, but there were, I guess you could call them a census, but it was basically a list of people, a list of names. Um, Back during the removal days of the 1830s, a lot of the people who were moving to Indian Territory filed claims against settlers, particularly settlers in Georgia, white settlers, who had confiscated their property because Cherokee law was, nullified supposedly before the Supreme Court ruled on it. But then, even then, it didn't really matter. So a lot of the whites who came in and confiscated farms and property, the improvements of the different five tribes, a lot of those people petitioned the Department of the Interior to reimburse them for those lost assets. And so they would create rolls of people who had claims against the government. But most of that's just kind of an early example. By far, most of the rolls of tribes began to emerge in the 1870s, particularly depended on where it was. If you were a Plains Indian, all right, in the 1870s, more than likely the United States government had your name on a list somewhere, all right, if they could figure out who you were, or if they could spell it right or something. So a lot of times, the agents would assign, sort of anglicized names to individuals so that they could keep track of them. And they were very interested in keeping track of the Cheyenne and the Lakota and Arapaho, and so forth. Why were they really interested in that? because they were survey they were the Plains tribes were under great surveillance during the 1870s in order to for the Army to try to control them. Okay, so that's when roles started to emerge, but by far most of the roles were drawn up in anticipation of allotment, as you probably recall. So allotment gets started in 1887, and the first process of that, if the land wasn't already surveyed, was the survey, right? But typically, like in Indian Territory, the land had been surveyed back in 1876, right? So it had been surveyed a long time. But the roles had to be drawn up. The roles of the potential allottees had to be created first, and so typically those roles of individuals would be the proof that that those people were owed an allotment. In the case of the Creek Nation, a lot of the citizens of the Creek Nation refused to take allotments, and so the government went down the roll and designated allotments for people without their presence. They weren't even there, and they got allotted land that they didn't even know about, which of course opened it up for swindlers, right? So today, most tribal identity is calculated or connect is based on a relation with a person who was listed on one of the final rolls. Okay, they often call them the final rolls because they, people are babies are born and people die, so the population's never static; it's always changing. So if you say that you're going to go out and take a roll of all the people, well, there are babies being born, and nobody's they're not going to be caught. So they often say that they often establish the roll to end on a certain date. So anybody born after that date would not be put on the rolls. But then later on, it was found that there were a lot of people who were missed, and so they have things called the newborn rolls, and the newborn the babies that were born like the year that the rolls were supposed to be closed were added onto the into the rolls. So anyway, it's kind of complicated, but the final rolls of a particular tribe usually provide the basis for tracing one's ancestry into the past. All right, and that idea of blood quantum is actually continued by the federal government today, by the Bureau of Indian Affairs, on if you're a member of a federally recognized Indian tribe, then you will have a certificate of degree of Indian blood, kind of like an identification card. That is a certification that you're a member of a particular federally recognized tribe. And on that CDIB card is a blood quantum. All right. So that's an official document of the United States government, like a driver's license or a passport. All right. So that percentage of blood quantum can sometimes be an issue when it comes to defining political, it's a politically created identity. So sometimes blood quantum is an issue when it comes to like criminal law enforcement in Indian country. All right. So did everybody read the case of, and you can look at the percentages here. Today, percentages generally aren't, that important, except for the fact that some tribes, like I said, are, remained. They define their own blood quantum cutoff. They, if they even have one, and like the Cherokee Nation, I don't think even has a cutoff at all. If you can trace your ancestry to someone on the rolls, then you can receive tribal citizenship. But anyway, in the case of United States versus Cruz, I think this was Tom Cruise. He was involved with this somehow. I don't know. Ted Cruz. Maybe it was Ted Cruz. No, it was do you remember the story here? There was a guy who was he was trying to deny his the crime, I guess, took place in Indian country. All right, so he's considered to be an Indian in this case, but unlike a couple of the cases that we've already discussed, like the Murphy case, the McGirt case, he's trying to deny being an Indian. All right. So, and it's kind of a confusing thing because his mother was it was 29/64 Blackfeet, and well, his father. Okay, number one, his father was Hispanic. His father was not a member of a federally recognized Indian tribe, and his mother was 29/64 Blackfeet and 32/64 Blood. And the Blood are a First Nation of Canada, not a federally recognized Indian tribe, not by the United States. So, the category, what is 29 plus 32 and divided by 64? What's that percentage? 90 something percent, right? So basically, mom was Indian, but was a descendant of two tribes, one in the United States and one in Canada. And his father was a non-Indian, so he was less than 50%, less than half. And okay, so given his heritage, he was 29 128 Blackfeet and 32 128 Blood. Now, the government determined that he had a they determined that he was an enrolled member of the Blackfeet tribe, which is a federally recognized United States Indian tribe, right? So he's 29 128 there. However, Cruz, denied this. He said, well, that's just kind of catching me based on my ancestry. So what happened was they utilized in this case something called the Bruce test, which came from a different case. And in this test, the United States had to it was the burden of proof was on the United States, on the prosecution, to determine two things, and that was that the individual was technically a tribal member, an enrolled tribal member of a federally recognized Indian tribe, which he was. And number two, he had to be a member. Let's see. He had to have basically some sort of connection to the tribe, and so it gets a little bit more complicated. So within that connection to the tribe, there has to be four, I believe it is, four categories. So you have to be an enrolled member, which he was. You had to have had some sort of federal assistance that is associated only with American Indians. He had to have had some sort of benefit from the Blackfeet tribe, and he had to have some sort of social tie to the community. If any of those four items couldn't be proved by the government, then the government couldn't actually call him an Indian. How did it work out? It worked out that the government, or in this case, a district court, the judge found that he did not see, or the majority. Um, well, it was a difficult decision, but essentially they didn't force him to be an Indian in this case. All right, so that's probably enough on identity. Um, Sorry about that. I keep just wave at me or something if I forget. Uh, okay, so with federal recognition, criteria, unique membership, who decides? Here we go. Here are the four facets of recognition, um, and the individual was able, the government wasn't able to prove its case.
Um,
Yeah,
Dr. Bass.
yeah,
So on one of the four, I think it also touched on here too. So the enjoyment of the benefits.
yeah.
I mean, what if he doesn't want them or doesn't
He
need them?
didn't. He didn't, and he
Yeah,
didn't.
exactly. So going forward,
He denied them.
someone else kind of assimilated more and actually didn't really use any of the benefits. Why would that really be a standard? That they'd have to use them?
Well, the government was trying to prove that he, that he was an Indian, and he was denying it. And this was the legal test developed in a different case to, basically the criteria that had to be there for the government to determine that he was an Indian.
Oh,
Okay,
got
so
it. Thanks.
it was the government standard, and the government, in the case of Cruz, it's not a really important case, but it's an example of how the government failed its own test. Okay, we're going to actually see some more examples of that today, which is kind of refreshing. Well, here in 1948, okay, in 1948, the United States Congress, and you might recall this, the United States Congress finally defined Indian country, the title of the course, right? And I mean, I keep the title of this course because even though, the term Indian is considered by at least most non-Indians I know to be offensive, all right, or at least to be less than sensitive, all right, and but that's of course not the reason I use it. It's the reason is because it is a term that has been codified by Congress in order for the law not to become ambiguous. Make sense? So, in discussion, I'll try to say sovereign tribal nation or Native American individual or, um, Choctaw or something like that. But in the case of discussing legal matters, uh, the law uses that term because it has been more or less used continuously in federal Indian law. Same goes with Indian tribe and Indian country. Okay, so Indian tribe, Indian country all have a specific meaning, and to change that would actually be very deleterious to Native people. So we don't want ambiguities in the law. So anyway, Indian country was defined by Congress in 1948. Well, what era were we in 1948? What era of United States federal Indian policy? Oh, now, you all need to be quick on your feet on that. Okay, 1948. That was 2 years after the Indian Claims Commission Act. Right? And just 5 years before PL 280. Right? So what era? It was after the IRA and before self-determination.
Termination.
Termination. Okay. Thank Arnold Schwarzenegger. All right. Termination era. And so, anyway, if this was part of the termination era, think about what this might mean. All right. I'm not saying that it was necessarily part of the terminators, okay, or the group within Congress who was actively trying to force assimilation by eliminating tribes. Anyway, so number one, there are three parts, okay, and two of them are pretty easy to understand for you all. All land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. What does that mean? Notwithstanding the issuance of any patent. What's notwithstanding mean? That's one of those often used legal terms. Clarity. Just to make sure we're on the right track. Notwithstanding.
In spite of?
In spite of, often used, yeah. So let's see, how is it used here? Is that what you got? In spite of? The man suspected of being the serial killer is little known to his neighbors, notwithstanding he has lived in the apartment complex for 20 years. All right. That's kind of a creepy one. So, yeah, I think that's a great one. Sarah, you said in spite of. That's a great way to say it. So, so the land within the limits of any Indian reservation under the jurisdiction of the United States government, in spite of the issuance of any patent. Okay, so even if there is a patent has been issued to an allottee, all right, what can happen to that? Even though a patent is issued, the allottee may, or the allotment may still be under restriction from sale, restriction on alienation. So that's why you have restricted allotments and allotments that are tribal or allotments in trust. So an allotment in trust would include a patent. Don't worry about knowing all that. It's confusing. But rights of way, what's that mean? Roads and railroads, anything having to do with going through it. Okay, so it's including an Indian reservation includes all of this. Okay. B, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. Okay, now that's the weird one. That's the one that it's very difficult to sort of define. But one way to kind of remember that is, okay, what's a dependent Indian community? Dependent, just forget about that. Dependent is synonymous with Indian in the case of this, all right? So all Indians are, except for people from India, all right, are dependent according to the United States government. So if you're a member of a federally recognized Indian tribe, you're a member of a dependent Indian community. But dependent Indian communities within the borders of the U.S., whether within the original or subsequently acquired territory. What would be a subsequently acquired territory? And whether within or without the limits of a state. So it could be within a territory. In 1948, did we have any territories? Had Alaska. Right?
Yeah.
Had Alaska. Were there any native peoples in Alaska? So yeah, they kind of fall into that. Another way I think looking at it is just imagine the pueblos. There's not necessarily a huge land base, but there's certainly a community. But anyway, it's kind of a catch-all. C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same. Okay, let's go back to this. A, I mentioned allotments. I probably shouldn't have mentioned allotments. Notwithstanding issuance of a patent and including rights of way. So in that case, if a tribe had land, received some sort of patent to it, like the Cherokee Nation did, or the Creek Nation did, or the Choctaw Nation did, they acquired a patent from the United States government to that land. So it includes them. All right. Okay, and then C is all Indian allotments, titles to which have not been extinguished, including rights of Indian title, meaning it hasn't passed out of federal trust in any way. Okay, and so that's it. And then I mentioned in 2020, the United States Supreme Court found that nearly half of the state of Oklahoma had in fact remained Indian country, and in so doing raised innumerable questions about the legal, regulatory, and political geography of the state, if you didn't know that already. So Indian country, we're in Indian country now. And that includes within the limits of any Indian reservation. The Cherokee, the Creek Nation we know now is an Indian reservation, and it was never disestablished. It was never annihilated. Okay, it still exists. Here's something on native or dependent Indian communities, and it's just kind of rough, but there's a case that we'll get to eventually called Alaska versus Native Village of Veneti tribal government, and that was not that long ago. It delineated two essential characteristics of a dependent Indian community. Number one, there has to be land that's set aside for the use of Indians in some with some paper trail, right? And secondly, the land has to be under the superintendence of the United States federal government. So basically, federal property and set aside for Indian use. That includes most of Alaska in 1948. But anyway, we'll talk about Alaska in one of the last chapters we get to. Any questions on Indian country? So we have a definition of Indian country, and it's a pretty inclusive definition. How about if, say my daughter, my daughter is 1/8 Cherokee, and she buys a house in Dallas. Okay, and the title to the house is in her name. Is that Indian country? No, has nothing to do with Indian country. So if you say no, you're correct. All right. What if let's say the Cherokee Nation has say they become, for some strange reason, they have a lot of cash, okay, and they want to invest that cash, so they buy farmland, and so they buy farmland around Stillwell, okay, or around Tahlequah, and they, with the intention of that land purchase is to expand a nursery, a tree nursery operation, okay, or maybe to grow strawberries in Stillwell or something like that. So the Cherokee Nation purchases, as it's a corporate entity, purchases land, and now that land is owned corporately by the Cherokee Nation. Is that Indian country? Oh, by the way, they purchased it from private owners.
I'm going with no.
Exactly, it's not, as we'll see in another case coming up. Now, could it be? Well, okay, let's say my daughter's house. Could that ever be Indian country? Not with her just owning it. Not with just her owning it. What about if the Cherokee Nation wanted to make that land that it bought Indian country? What would it need to do? Could it do it? In most cases, yeah, it could do that. Most cases. However, it would have to petition the federal government to place that land into federal trust. When did that become possible? Technically, you recall? I mean, technically, it became possible when John Collier, got the Indian Reorganization Act passed, or in the case of Oklahoma, the Oklahoma Indian Welfare Act, 1936. But the federal government can and has placed land into federal trust, land that's been purchased by Indian tribes. One of the more common examples of that happens in metropolitan areas. Okay, and this is when it gets really interesting. States often get involved. Typically, states and municipal governments try their best to have Indian tribes to first of all get land and then place that into federal trust. For what reason?
No taxes.
No taxes and no prohibitions on gaming. Yeah, exactly. Are they successful? Not always. Not always. Sometimes they are. Sometimes they aren't. As we'll see in the Indian Gaming Regulatory Act. Okie dokie. All right. So, are there any comments or questions on Chapter 13? I didn't discuss the United States versus Arrieta, but that was an example of dependent Indian communities, a test for dependent Indian communities, and we already talked about that. So land has to be set aside for exclusive Indian use, and the lands have to be under federal supervision of some sort.